Good morning, all of you. Welcome to Legal Matters by Sai Baba Sankara. Honorable Supreme Court of India, in the case of Chabi Kamrakar and others versus the State of West Bengal, in a recent judgment delivered on 29th August 2024 relating to writ petition criminal appeal number 1556 by 1556 by 2023 held that when the dowry demand or demand for dowry is not established, punishment cannot be given under Dowry Prohibition Act. It is as simple as that. ఎప్పుడైతే 304B of the IPC కింద 113B of the Indian Evidence Act ప్రకారము if the death occurs within 7 years and if before death, soon before death, if she is subjected to the so-called harassment for dowry, it's called a dowry death. When that demand for dowry is not established, but she died, then you cannot convict him under 304B IPC. He can be convicted under other sections. Ani Gauraniya Supreme Court, 2 judges bench, Justice Sudhanshu Dhulia and J.P. Parthiwala bench. They held on 29th August 2024. The main point is the prosecution was not able to prove the dowry harassment, but basing on section 113B of the Indian Evidence Act, he was convicted, and this conviction is set aside by the Honorable Supreme Court of India. ఒకసారి కేసు పూర్వాపరాలకు వెళితే మనకు అర్థమవుతుంది. Actually, this is a case relating to the provisions of section 498 IPC, cruelty or harassment by husband or his relatives, 304B, dowry death, 306, abetment to commit suicide, read with 34 IPC, all these sections. So yeah, abetment to commit suicide is there, dowry death is there, previously before dowry death 498 IPC, all these sections are there. Right, the deceased Sonali Kamrakar, that is daughter of Chabi Kamrakar, Sonali Kamrakar, and the husband, she married the husband on I think in the month of March 2003. The marriage took place in the month of March 2003. And as a result of their procreation, or as a fruitful result of their marriage, a son was born in the year 2004. 2/9/2004, the son was born. Right? But of course, their happy family life is short-lived, because on 2/5/2006, she committed suicide by hanging to the fan when none of the inmates were present. Actually, the child was present, and child cannot do anything, but just 2 years baby. Husband was away from the home. He was not in the house. Lot of issue was made, and the Chabi Kamrakar and others held that the husband and relatives, that is sister-in-law, his sister, and mother-in-law, all of them are responsible for the dowry harassment and death, and they have given a complaint, under which sections the FIR was registered already in Kishanganj PS of Nadia, NADIA. Right. The body was sent for PM examination. The postmortem examination clearly noted the ligature mark around the neck, and the PMC disclosed that hers is a suicidal death. As far as evidence is concerned, of course, he was convicted for life, she was convicted for 3 years, mother-in-law was convicted for 2 years, like that. The convictions was given by the trial court. High Court also said that they are not going to interfere as per the 113B of this because the burden of proof lies on the accused person in this case. Ultimately, they approached the Honorable Supreme Court of India. Here the important point is, no doubt PWs 1 to 3, they deposed as per the statements recorded to the police under section 161C IPC that there was harassment for dowry, that she was subjected to cruelty by the husband, by the sister-in-law and mother-in-law. But the independent witnesses, they brought out the real fact. The fact is that husband is having an extra marital affair with another woman. This woman used to, that is the deceased Sonali Kamrakar, used to question him and used to beat her. The harassment continued like that, not on the demand of dowry. The father also stated that he gave the money, but he gave evasive replies. He could not produce the dates on which he paid the money and also from which he borrowed or from which bank he has taken out. All these things they cannot prove. Ultimately, here the main point is the harassment for dowry is not proved. When the harassment for dowry is not proved, how can you punish him under dowry death? It's not correct. So therefore, Honorable Supreme Court of India set aside the conviction. Against also not proved. So trial court, only basing on section 113B of the Indian Index, that is presumption, that the burden of proof lies on the accused person. They have given conviction. It's not correct. Supreme Court set aside the conviction. Very good case law. Very good for the defense advocate. Please read the case law and enrich your legal knowledge. With this, I am concluding. Thank you very much.